Thank you, everyone. Please be seated. We are here this morning. It's our first day of the new term, kind of like our first day of school. We have 3 cases that are set before the court today. The case of the matter of VH is hereby submitted without oral argument. And our first oral argument today is UE Local 893 versus State of Iowa. And it looks like the parties are ready. And it's my understanding Mr. Mukkada will be arguing. Is that correct?
Yes.
Okay, thank you. Go ahead.
Thank you, Chief Justice, and good morning. May it please the court, counsel. My name is Joe Mukkada. I'm an assistant attorney general, and I represent the state of Iowa in this case. In 2019, this court held that the state of Iowa and UE did form 2 collective bargaining agreements covering the years 2017 through 2019. Now this court must decide what those collective bargaining agreements actually say. Now there's 3 main points I'd like to discuss with the court this morning. Number 1, the state did not breach the collective bargaining agreements when it did not deduct dues from employee paychecks, because under the plain and unambiguous terms of the 2017-2019 agreements, the state could only deduct dues upon receipt of voluntary individual requests from employees covered under the agreement. Because the state did not receive such authorizations, the dues deduction provision was never triggered. Number 2, even if this court finds that the state did breach the agreements, the proper remedy in this case is the retroactive deduction of dues, not money damages. This effectuates the purpose of the dues deduction section, which is for the state to transfer union dues from union members to the union, not for Iowa taxpayers to fund unions through the public fisc. And finally, even if money damages were a proper remedy in this court's opinion, the court should find that the union failed to mitigate by not taking the reasonable step of simply asking their union members to provide authorizations under the agreement. And I think it's helpful to give some background on how these agreements were actually formed. UE represents 2 state employee bargaining groups. Under Chapter 20, UE and the state are required to meet every 2 years to negotiate, and in this case, the state made a proposal and the union ratified it. Now, here we do not have a 2017-2019 agreement that was ever reduced to writing, but we do have definite and specific terms for the court to look at, and what you would do is you would look at the state's proposal. The state's proposal references the prior CBA, the 2015-2017 CBA. And so you look at those together to determine what are the terms that we're looking at. And it's important to consider that this is not a continuation of the prior agreement. This is a new agreement that succeeded the prior agreement. Now, I think it's important to look at what does the 2017 through 2019 CBA say and what doesn't it say. The section that we're mainly discussing is Article 2, Section 2, which is the dues and fees deduction section. And it says under paragraph A, upon receipt of a voluntary individual written request from any of its employees covered by this agreement on forms provided by the union, the employer will deduct from the paid dues such employees those dues required as the employee's membership dues in the union. The agreement also has an integration clause under Article 15, Section 1. It says, this agreement represents the entire agreement of the parties and shall supersede all previous agreements, written or verbal. Yes.
The state and the union would have agreed that the union ratified it in February and they wouldn't have gotten into this litigation. Would the state have required new authorization cards?
I believe the answer is yes under the terms of the agreement. I think the way the state is reading the contract language is that they required authorization cards to be provided. Only upon the receipt of those authorization cards would they deduct dues.
Agreement include that same language?
It does include the same language, Your Honor.
Require new authorization cards from the prior year or from the prior term?
Parties have stipulated that that the state has never required authorization cards in prior years. But I think 2 answers to that. In this case, if the terms of the 2017-2019 contract, which succeeded the prior contract, if those terms are clear and ambiguous, then we don't need to look at extrinsic evidence such as past party practices. We can't really draw anything from those past party practices because the only CBAs that are in this record are those two CBA terms. And so we can't really say that, because it's possible that prior contracts had a survivor clause.
You say upon receipt is unambiguous, right? I mean, why does upon receipt mean they have to receive it after the agreement, the 2017, 2019 receivement is signed? What if you've already received it? Why isn't that good enough?
Answer, Your Honor, is if you look at the 2015, the prior CBA, the 2015-2017 agreement, it doesn't have a survivor clause, so it doesn't say explicitly that authorizations that were received in prior agreements will continue to be valid into future agreements. But what it does have is a termination clause, and it says the terms and conditions of this agreement shall continue in full force and effect commencing on July 1st, 2015, and terminating on June 30th, 2017, unless the parties mutually agree in writing to extend any and all of the terms of this agreement. Upon termination of the agreement, all obligations under the agreement are automatically canceled. So the obligation to deduct dues based on authorization cards that were on file before July 1st, 2017, that obligation terminates. A new CBA took the place of the prior.
Which in the proposal that was submitted by the state, wasn't it just bracket status quo or bracket same, something like that?
It was actually more specific. And I think this is the key distinction between what the union made their first proposal, and under the Article 2, Section 2 dues deduction section, the union says status quo. Now, I think you could read that, and I think the union implies in their arguments that implies that all the practice, everything that was going on in the prior CBA would just continue. But what the state proposed was something different, which was that current contract language. That was in the state's proposal. That's what was ratified. So the current contract language simply transfers the language that was in the prior CBA into the current CBA. It doesn't, by its very terms, take into effect some kind of other extrinsic evidence that wasn't in the contract that was ratified.
Something about the meaning of the language based on what happened with the prior contract with the exact same language. And as I understand it, it was the state's position then that it would not require new authorization cards.
Once again, if you're looking at those prior practices, then this court has to determine that the language of the 2017-2019 CBA is ambiguous, which none of the parties are arguing in terms of how it applies to the breach issue. But then we don't have, I think if you were looking at prior practices, and if UE would rely on that position, for instance, you would need to be able to compare the prior practices to the prior CBAs that were in place. So it's possible, for all we know, that a prior CBA, it's not on the record, but a 2013 to 2015 CBA had some kind of survivorship. And if you're looking at
Body of labor law that indicates that past practices are actually incorporated into and part of the CBA. Is that relevant here?
it is ultimately, generally speaking, when terms are unclear, when it's ambiguous, then it may be appropriate to look at past practices or industrial common law. Generally, how this court has used the industrial common law is when it's reviewing, it's a standard judicial review for arbitration decisions. And the purpose of that is because it gives greater deference to an arbitration decision so that the parties will adhere to the arbitration decision. They won't just go to the court every time they disagree with an arbitrator's decision. But here, if the language is clear and ambiguous on what was required of the state as it pertains to authorizations, then the court does not have to look to extrinsic evidence. And I don't think either party or the district court relied on that.
It's a question of law for the court. You don't have a fallback position that this needs to be remanded for a trial on any extrinsic evidence?
No, Your Honor. I mean, I suppose if the court found that that there was a need for extrinsic evidence, it would be concluding that the terms are ambiguous. And so then I suppose the court could remand it for that to...
Anything else to look to in this record besides the language of the contract and the past practice?
No, I don't believe so. I mean, I think what's in the record is two terms of CBAs, 2015 to 2017, 2017, 2019, effectively. And just, I think there's an affidavit from a union representative just saying that, that was the past practice, but nothing additional. But even if this court did find that the state was liable for breach,
And maybe that's where you're going. So I think there's a pretty large body of labor law that indicates in these kind of dues check off, failure to withhold, that the employer can be liable and pay those damages because this is a breach of contract case, right? You wouldn't retroactively assess employees for the employer's failure to deduct these dues. So is that body of case law relevant here? And two, if it is there something unique about the state as an employer that makes it not applicable?
well, I think there's two issues with that. So to answer the second part of your question, I mean, I think when there is obviously an issue of sovereign immunity, and so when the state is opening itself to being sued for breach in contract, the state is only liable for what it agrees to in the contract. It doesn't mean that anytime the state is in contract, it can be liable for anything under the sun. But to the first part of your question, I don't know if the industrial, there are several cases, and they are mainly based on provisions of the Labor Management Relations Acts and enforcing those provisions, different from Chapter 20. But Iowa law is clear that damages stem from what is within the contemplation of the parties in the contract and what is the nature and purpose of the terms in the contract. And so in this
But the employer under Iowa labor law just said, I know, let's assume there was an explicit agreement and you had the authorization cards to deduct the dues, and the employer just said, I just don't want to do it. I know I agreed to it. I'm not going to withhold the dues. I'm not going to transmit them to the union. Clear breach, intentional breach. What's the damages in that case?
Well, I believe you have to look at what are the terms of the contract explicitly. I mean, for instance, there could be a damages provision. There could be a liquidated damages clause in this contract.
To say that the employer just said, I just don't want to do this.
It would still be, assuming there is no bad faith argument, there aren't some kind of damages for that. I think the remedy could still be and should be a specific remedy of doing what was agreed to in the contract, which is the service.
Ask you about that, because I'm trying to think of another situation in which a plaintiff is asked for damages in a breach of contract case, and then the defendant says, no, we prefer that the remedy be specific performance, even though there's a clear legal remedy of damages. You're basically saying you get to choose the equitable remedy, and that it was somehow an abuse by the district court to not give that equitable remedy instead?
I think our position is that under the terms of the contract, what's demanded is an equitable remedy for a couple reasons. If you look at what was breached was not that the state was required to pay dues or was required to remit money to fund the union. What was breached, if there's breach, what was breached was the service that the state provided, which was transferring dues from the employee to the union. I don't think anyone disputes that it's the employee that owes union dues. And
We do that here, though. So let's take a typical contract case where party A is going to provide party B with some product and they fail to deliver. It causes damages to the business of party B. Party B sues for damages and they get to trial, and party A says, no, actually, we'll deliver the product now, like 5 years later. We would never think of a contract case that way, even though that's what they contracted for, was the delivery of the product. So you get damages. It's a pretty common remedy. I don't see why this case is different.
in that case, under your hypothetical, if I follow correctly, what's being contracted for, if a company sells 10,000 widgets, they deliver the widgets, and then the state doesn't give them money for the sale, well, then it's obvious what was contemplated in that contract. But here, it's something different. And there's a case cited in brief, Royal Indemnification Insurance.
Party doesn't pay, it's that the party doesn't deliver the product. the remedy doesn't get to be decided by the breaching party after trial and say, oh, well, actually, we don't want to pay damages. We'll perform 6 years later.
I think still in that case, it would be contemplated that if product wasn't delivered, for instance, in a sales contract, in a run-of-the-mill sales contract, that would be the logical damages that would follow. And I guess I'm referencing that Royal Indemnification case where they talk about, does the service that was provided or what was contemplated in the contract, does that match what's being claimed by the person who's claiming a loss? And here, the union is not paying for this service or anything. There's $0 being paid for that service, but now they're claiming $1 million in damages. I think what's referenced in that case is that there was a service that was $40,000, and then because of loss, the claimant was saying they were owed now $250,000. So what's considered in the contract has no bearing in relation to what is now being claimed by the union. And the specific performance remedy would fulfill, if under Chapter 20, this court has the power to enforce the contract, were the state in breach, this would enforce the contract. The state would then retroactively deduct dues from employees who clearly are the ones who owe the dues, and that would effectuate the purpose. Finally, I'd like to just briefly mention mitigation damages. I believe the union's
If you want to, that's okay. Thank you. Fun, doesn't it?
Chief Justice Christensen, Justices McDermott, McDonald, Waterman, Mansfield, Oxley, and May it please the court. I'm Charles Gribble. I'm here with Chris Stewart, and collectively we represent UE, the employee organization. This is an appeal from the Polk County District Court by the state, only with respect to dues deduction, not with respect to any other part of the award that was rendered by the court. UE was first certified to represent the Social Services Unit in almost 30 years ago, in 1994. And they were certified to represent the Social Services Unit in 84, and the Science Unit in 1995. So for all of those years, we've gathered authorization cards. In other words, they never expire. Some of them are as old as going back almost 40 years. The only one that can revoke the authorization is the employee. Now, as to whether there's a dues deduction provision in the 1719 contract, there is, and we'd call the court's attention to Appendix 236. The local association, in making its initial proposal, that would have been in December of 2016, for the 1719 agreement, specifically stated that all the provisions of the 1517 contract will continue into the 1719 agreement, unless specifically they sought otherwise. With respect to Article 2,
well, let me ask you this. Did the 1517 contract, right? Does it have anything in there that says that the dues deduction authorizations from, what would it be, the 2013-15 contract, that those have to be honored in the 1517 period? Does it say that?
Your Honor, no, is that necessary? Because the dues deduction, the authorization cards never expire. They continue on from the time they were signed, some of them as early as 1984, others as early as 1995.
That in the contract, because what the state's pointing to is like page 27 of their brief. They point to this contract language that says, obligations from a prior contract expire and they don't continue to the next contract. I'm trying to see what in the contract requires the obligation or requires the conclusion.
These are mature collective bargaining agreements, 2-year agreements every year in one case, starting in 1984, the other in 1995. And specifically, in answer to your question, Your Honor, the union did state specifically in the negotiation for the 1719 contract at Appendix 236 that everything contained in the 1517 contract would continue That was their proposal unless specifically altered or changed.
That would mean that the written terms of the contract would, from the 2015-17, would then be the written terms for the 17-19, correct?
I made a proposal. Now, because it's a mature contract, very seldom does anyone open on all the provisions of the contract. The employer only opened on a few. For example, on wages, they proposed a 3.25% increase. We accepted their entire proposal on February 14th of 2017. That's what created the contract. And the employer's position was the same as ours on dues deduction, current contract language.
Just trying to find in the language, some language that supports your position on this.
The law in the state, there's no law that says that authorization cards expire at any time, that they have an expiration date, that you need to get them for every contract, quite the reverse. They all continue unless the employee initiates a request to revoke that authorization, which they can do after 1 year with 30 days notice. But the employer can never revoke it, and the employer can never insist on new authorization cards.
For that.
It's been the law in Iowa forever. It would be the employer that would have to point to any deviation from that fact. Those authorization cards have never expired. And as we said, in addition, that's been the party's practice for 40 years in one case and 30 in another. Never has the employer taken the position that you need to get new authorization cards. And it would be literally impossible, Your Honor, because we represent 1,800 employees in one unit, 450 in the other. They're scattered throughout 99 counties in the state of Iowa. So getting new authorization cards would be extremely difficult, nor is there any requirement that we do so.
Those facts, and those are all important extraneous facts outside of the language of the contract. And we have case law that says that even when a contract's unambiguous, that there can be a fact issue if there are questions arising from the extraneous evidence in a case. And so I'm just kind of wondering if that's not this case. Since there's nothing clear in the contract that says that dues authorizations from prior contracts have to be honored by the employer. So there's really nothing in the written language. And then on the other hand, we have some extraneous evidence, as you've talked about. If I think about some of our prior cases that have talked about weighing that kind of evidence, I just wonder if that's not a fact issue at the end of the day.
So, Your Honor, because they're clearly in the 15-17 contract, and in negotiating the 17-19 agreement, the union specifically proposed to continue all the terms of the 15-17 contract into the new contract unless they made a specific proposal to modify. And they said,
Proposal was status quo, and the state's proposal was same contract terms. Are those different things, or are they the same thing?
exactly the same, expressed just in different terms.
With the term that says all obligations cease at the termination of this agreement?
Except we negotiated the new contract. These contracts were right together. In other words, there was no time when there was not a collective bargaining agreement in force and effect. The 15-17 contract went to the end of June of 2017, and the new contract, the 17-19 contract, started July 1. So,
In a break, if there had been, the negotiations had failed and it would have terminated and it took a while to renegotiate, then would the authorizations have been good, or would they have needed to require new ones?
cards still have been good. Now, the terms of the contract, the parties may have reopened on new matters, or we could not have enforced a breach if there was a 6-month gap in the contract terms.
It was a carryover that was ratified in February before it would have expired. Okay, thank you.
Found in May of 2019. So with respect to this particular case and the damages, there's been some discussion of that. We would point most importantly, I think, to the food handlers case, the 8th Circuit case, which seems to be pretty much on all fours with this situation.
Does the amendment to section 70A.19 matter in this case?
It matters because it matters and it supports us. What it said, 17A19, is that after February 17th, the employer could no longer deduct dues for employee organizations. But specifically, 70A19 said that it does not apply to contracts that were negotiated and ratified prior thereto. And as you found in 2019, this contract was in fact ratified 3 days earlier on February 14th. So it does not apply.
I want to ask you about the state's argument that you're not entitled to a damages remedy. There is some difference between the language of the federal LMRA, Section 301, the general provision allows you to go to federal court to enforce a collective bargaining agreement. And that talks of suits for violation of contracts between an employer and a labor organization. And that clearly authorizes damages suits. The Iowa law is worded a little differently, and it was written, came along after the LMRA, and it says, terms of any collective bargaining agreement may be enforced by a civil action. What about the state's argument that enforcing means specific performance? You enforce an agreement by forcing the parties to comply with it, not by awarding damages.
Your Honor, the enforcement, we would say that the damages flow here from the breach of the contract that occurred and were foreseeable. What the employer did in this case in June of 2017 is that the union had been receiving $30,000 every 2 weeks at that particular point in time. At that point in time, they left the union without any particular way to compel them to go ahead and complete their obligations. In other words, they were still the certified bargaining representative at that time. They still had the obligation under 2017 to represent everyone in the bargaining unit fairly. The employer knew that, and the employer knew that 70A19 was not a defense, did not allow them to go ahead and refuse to honor the dues deduction provision of the contract. So even though 301 is not in our law, what I saw the food handlers case saying is that we're looking at labor policy, good labor policy, which is the same under 8A of the NLRA and the Public Employment Relations Act. It talks about bad faith bargaining. And in essence, the court says what the employer did there, and we say here, is the essence of bad faith, not honoring a contract provision, or in food handlers, not reducing a contract provision to writing. So we would say that
Court find bad faith?
case, they did not. I mean, I think the only place I see any reference to bad faith would be with respect to the attorney fees argument. And our argument there is that it flows from contract just like food handlers, where in essence they said, in that case, the employer's refusal to honor the collective agreement by refusing to reduce it to writing, here, refusing to abide by it, knowing that 70A was not a defense, knowing that you're going to leave the union who represents 2,500 employees without any money. They've been getting $30,000 every 2 weeks. Certainly the employer knew what it was doing. Certainly those damages were foreseeable. And certainly we don't believe the employer can transfer its obligation to pay those damages to the employees, which we represent in this particular case.
Damages to the employees. Part of the damages that are not part of the appeal, at least, are back wages, as I understand. Why should the dues not come out of those back wages, at least for those?
Your Honor, first of all, let's remember that the employer only raised the dues deduction here on appeal. If we look at the district court decision, the employer never said, well, if you're going to rule against us on dues deduction, deduct it from the back pay. That argument was never made. That's being made for the first time here, that you should find a way to deduct it from the employee's paycheck. Based on the amount of damages, union dues are $1,042,000. The back pay and the overtime are less than $900,000. The employer's given no indication how that would be done, and they didn't, most importantly, argue it below to do that.
Let me switch gears with you just for a minute to this question of mitigation. It seemed like to me that the district court thought that since you had no contractual obligation to go get new authorization cards, that automatically means that there could be no duty to seek out authorization cards as a mitigation measure. Is that fair? Okay.
Matter of law on that.
About that, because isn't it true in other contractual situations that sometimes the duty to mitigate will require folks to do things that they weren't obligated to do under their contract? I mean, sort of the landlord-tenant example, for example, you have a landlord-tenant agreement and the tenant breaches, well, the landlord then has to go out and find a new tenant to mitigate, right? That would be the law school example. But the contract never obligated the landlord to go get a new tenant necessarily. It's more of a broader duty to mitigate. So I'm wondering if there couldn't be a duty to mitigate that's actually broader or different from what was necessarily required under the contract.
Handlers, the case we rely on, there is no duty to mitigate, Your Honor, but in this case, the union made extraordinary efforts to mitigate. They hired Union Track, and they were able to recover $400,000, less about $50,000 in costs. So the union went above and beyond in doing that. But as far as the authorization cards, with respect to those, we started collecting those authorization cards in 1984 in one case, in 1995 in another. The employees are spread over 99 counties in Iowa, so really it was not feasible. And had we done that, remember the state was saying, unless you do that, we won't deduct the dues. So they're posing a non-legal requirement to continue deducting the dues, which the union could not agree to or acquiesce to. Thank you.
Justice May, I'd like to follow up on your line of questioning on the failure to mitigate. The Counsel v. Freeman Brothers case, I mean, says that the person's required to mitigate, to take all reasonable steps, essentially take all reasonable steps to mitigate the damages. I think another example would be wrongful termination case. There's nothing in the contract saying they need to find a new job. They're not required by law to find a new job. But we expect them to do something to try to find a new job and replace that lost income. If they don't take those steps, we find that they haven't mitigated.
Standard of review, though, that the district court made a factual finding that the plaintiffs made reasonable efforts to mitigate. Isn't that binding on appeal if it's supported by substantial evidence?
Or can review whether the standard of mitigation is met, whether they've taken all reasonable steps. I mean, it's certainly presented to the court that they didn't, and I think the court can review that finding.
District court's the fact finder on that issue. We don't redecide facts. We're looking for legal error.
It found, I mean, it's undisputed that they didn't send out a request from members to provide authorization cards. The district court's conclusion, I think if you read the opinion, is that they weren't required to under the law or under the contract, and that is not the application. That's not the correct application of how to find whether someone was mitigated.
Say it's really simple, they should have just got new authorization cards, and your opposing counsel says it would have been really hard. There's thousands of employees over 99 counties. Is there evidence in the record that addresses how easy or difficult that would have been?
I think what's in the record is just the argument you just heard from the union. I don't think we have to. I don't think the union has to show that they would have gotten all the authorization cards. The question is, did they take the reasonable step? And the union just flat out refused to. And so that's the issue we're dealing with. One thing I didn't mention.
What they're alleging is your refusal to just plain honor it. So you're asking them to go to a whole lot of work to minimize something that, according to prior practice, had been accepted. Isn't that true?
Your Honor, I mean, this just pertains to the mitigation issue. So obviously there is a dispute that's underlying this whole issue.
Yeah, there was a 2-week gap, perhaps, where you just plain stopped pulling before the first contract was up. So even if we were only talking about those 2 weeks, there's a period of time where you did not pull, correct?
I believe that is reflect in the record. I don't know why that is. I don't know if that has to do with the timing of.
Have collected the dues if these cards had been provided? I mean, the state was arguing until May 2019 that it was unenforceable. There was no agreement. So how would that have mitigated?
There was an open question in the state's view whether it was enforceable, and so it was kind of a, and it's a violation. If it wasn't enforceable, it would have been violation without authorizations. And I think also around this was a question of whether many of these union members.
At the state until May 2019, which is almost the date it expired, was arguing it wasn't enforceable, right?
Correct. And I think under the terms, the state's position is that it needs authorization cards, even if the contract, there's a question whether there's a contract at all, but now it's concluded there is a contract. The state's position was still that it needed authorizations to begin deductions, and that's what's underlying that request.
March 2018 letter, was there a letter about that?
There is a letter, and we have in the record 3 union representatives testify that they're aware that the state requested. If you can provide these authorizations, then we will deduct going forward, and we can also deduct retroactively. So to wrap up, we just ask this court to reverse the district court and find that the state did not breach the contract. If it finds that the state breached the contract, we'd ask that the court order specific damages to order the remedy of retroactive dues deduction. And if the court finds that there was a breach and that the state failed to mitigate, we ask that if the court finds that the state breached and that money damages is the appropriate remedy, we ask that the court find that the unions failed to mitigate. And finally, we would ask the court affirm the district court's ruling on attorney's fees. Thank you.
Affirm the district court ruling that you owe money judgment. Does the state plan to go back to the employees and retroactively collect dues? And is that anything we need to decide, or is that a question for another day?
Anything you need to decide, that'd be a question. I think that's possible for the state. I'd also note there is a indemnification clause in the dues deduction section from the union as well, but you don't have to say that. Thank you.
Your Honor.
Yeah, oh, that's true, cross appeal. I'm sorry, I forgot about the cross appeal. I had that look on my face. You're like, what are you thinking? Sorry about that. Go ahead, Mr. Gribble.
Just to address finally the question, we think here the dues clearly are the responsibility of the employer. The damages were foreseeable in this particular case. They knew what they were doing. They knew that 70A19 at the time that they stopped deducting dues did not provide them with an out, that it said that with respect to contracts negotiated before February 17th, that section saying they couldn't deduct dues did not apply. Because the employer knew that and also knew the foreseeability of harm here, where the union was getting $30,000 every 2 weeks and yet had to continue its obligations under 2016 as a certified bargaining rep and under 2017 to fairly represent everyone in the unit, whether they're members or not. For any business to continue to do that without any money is going to place them in a very difficult and very foreseeable position. So we don't think that the remedy of trying to get that money back from the employees under these circumstances would apply. With respect to the attorney fees provision, again, we'd pretty much look to the food handlers case, which is, we think, almost on all fours with this one. We realize, Your Honor, the difference on the 301 cases, but we would say with respect to the bad faith, that's encompassed in both the Public Employment Relations Act as well as the National Labor Relations Act. And in that particular case, they found what the employer did in refusing to reduce to writing the dues deduction provision was such evidence of bad faith that attorney fees were warranted in that particular case. And remember, in food handlers, what the employer tried to do, they tried to put in, when they reduced the contract to writing, a provision that would have required authorization cards, new authorization cards. And the union said, we never agreed to that, and the court agreed. So the prior authorization cards, of course, were good. So in that particular case, we would say attorney fees are warranted here, one, because of your 2019 decision. You said there was a valid and enforceable collective bargaining agreement. The employer knew the terms of that contract. How did they know? We accepted their initial bargaining proposal. In other words, everything that was in the 17-19 contract was what the employer proposed on December 20th of 2016. Yet they didn't apply it, they didn't implement it, and they did not apply it for more than a period of 2 years. Now, why is there such a difference between the union dues of $1,042,000, and remember the back pay and the overtime are less than $900,000? That's because in March of 2018, the employer did start to make some back pay payments. That's the difference there. But again, we'd have to say the employer did not start to deduct dues. And again, this issue of the specific performance was not raised before the district court. You won't find anything in the district court's opinion about that. There's nothing there that the employer argued that if we can't get the remedy we want here, which is that we don't have to pay dues at all, then our alternative is get it from the employees. There's nothing there. Those damage amounts, the back pay and the overtime are clear. They're the result of the court's finding, and the employer never asked that those be reduced.
Attorney fee standard in our case law generally is a very high burden, greater than even that required to recover punitive damages. Did the trial court make an adverse factual finding against your fee claim?
The trial court said simply is that there were legitimate issues that needed to be resolved, and on that basis denied the attorney fee provision. We don't think, looking at the contract itself, given that it was the state's proposal that we accepted, that there really were legitimate issues there. None were raised before the 2019 decision. The employer didn't argue, well, there are certain provisions of this contract that we don't think we agreed to. I think you resolved that in 2019. And their failure to implement that award.
We'd have to find, as a matter of law, their conduct on this record constituted bad faith.
Your Honor, that can be found on the basis of that 17A19 does not give a defense to the employer at all in this particular case, and that the damages were foreseeable where they knew the union for 30 or 40 years in each of those cases represented those employees. The only way they had money to go ahead with their obligations under law was from the dues. They cut them off completely. They were left without anything. Thank you.
The case is hereby submitted regarding UE Local 893 versus State of Iowa. And the next case can approach the bench as soon as these parties are ready. Next case will be State of Iowa versus Erdman.